You brought a medical malpractice lawsuit against your doctor claiming that he was careless and his carelessness caused you significant harm and injury. Your case goes all the way to trial. And now, during the middle of your trial, you agree to settle your case. Both parties reach an agreement to settle. Why is it that you are now asked to take the witness stand after you've agreed to settle this case and now swear to tell the truth and now testify under oath? Why does that happen? You want to know the answer? Come join me for a moment as I share with you exactly why it happens. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So here's the scenario. You brought a lawsuit that now goes all the way to trial. And during the course of trial, the defense attorney and your attorney get together, and now they reach a mutually agreeable solution, which is to settle your case. Great. Now your case is over. You've agreed to settle for a certain amount of money, and there are certain conditions as part of your settlement. Terrific. But before you can go home, your attorney tells you, wait a second, you can't go home yet, you can't leave yet. You need to get up on the witness stand and testify. And you're looking at him and asking him, why do I have to testify? The case is over. The judge sent the jury home. Yes, that's true. But you getting up to testify is not for the benefit of the jury. It's not for them to evaluate your credibility. It's not for them to decide whether you are slightly more likely right than wrong that what you are claiming is true. So then you turn around and ask, well, why is it? Why do I have to get up and testify? Well, the answer is you have to get up and testify in order to make sure that this settlement is valid, in order to make sure that you are doing this settlement, that you are agreeing to settle this case and end this case forever of your own free will. The judge wants to hear it from your own mouth that what you are doing is voluntary. The judge wants to hear that you are in agreement with this settlement, that understanding you have now spent 2 or 3 years to get all the way to trial. Now you have finally reached trial, and now you are very close to putting this in front of a jury to get a verdict, hopefully in your favor. And now you're giving all that up. Why? Because now, in exchange for a certain amount of money, you are agreeing to resolve your case and end your case. And the judge wants to hear you say it. In addition, the judge wants to know if you're on any type of medication that might alter your ability to understand exactly what's going on. Mrs. Jones, are you under the influence of any drugs or medications? Yes or no? Mrs. Jones, are you doing this of your own free will? Do you understand the ramifications of going ahead and settling this case? Do you recognize that once you are done today, you can no longer come back, ever come back, and restart this case or reopen this case against your doctor? Do you understand that? Mrs. Jones, do you understand that once you settle this case, you can't come back a week from now, a month, a year, 10 years from now, asking for more money? You do understand that, right? So that's part of the reason why we have you get up on the witness stand to go ahead and explain to the judge and testify under oath that you understand all of these factors. Now, who will be questioning you when you get up to testify? The answer is your own attorney will question you. The defense lawyer is there observing, the judge is sitting there listening and paying attention, but it is your attorney who's going to be asking you these questions. Mrs. Jones, you understand that an offer has been made to settle your case? Yes. And you understand that the defense has offered $1 million to settle your case? Yes. And is it your testimony that you have agreed to accept their offer? Yes. You understand that by going ahead and accepting their offer to settle, you can no longer come back to this court ever again to try and obtain more money? Yes. And Mrs. Jones, are you under the influence of any drugs or medications today? No, I'm not. Have you taken any prescription medications today? No, I have not. By having you get up on the witness stand and testify under oath, what we are doing is putting this settlement on the record. Now the defense is protected. Now your attorney is protected. Now everybody understands what's going on and what is happening in exchange for this amount of money. Here you go, Mrs. Jones, you're going to get $1 million once we get all the appropriate papers to sign and finish up this case. And after your attorney is done questioning you, the judge may ask a few follow-up questions. Hey, Mrs. Jones, you're aware that your attorney will receive a fee as part of his efforts? Yes, I do. You're also aware that he will receive legal expenses that he has put into this particular case? You realize that, yes? That he will be reimbursed for that? Yes, I do. And Mrs. Jones, are you satisfied with the efforts your attorney has made during the course of this entire litigation and throughout the trial? Yes, I am. Terrific. I now mark this matter closed. This case is settled. Have a nice day, everybody. That's exactly what happens when you settle a case in court during the middle of your trial. You have to get up and testify, even though no jury is present. Now, your case is over. You swear to tell the truth, and now you're asked these series of questions. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are now thinking about bringing a case, What I invite you to do, if you still have questions, is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.